Oromiyaan lafuma Oromummaan lafuma yaaduma qabeetu tumi jedhanii dhumu. Barra waan qabu waliin qaba waan dhabu waliin qaba ayyaantummaa qabu hin eeginaa hin cabu. Barra. Gaafa guulaa nu guulchisa, gaafa duulaa nu duulchisa. Waan galgala abbaa eeggatu, yoo beekkatan guyyaan beekkatu. Goonni diinaan girree bu'aa, gaafa xiiqii sabaa bu'aa. Gaafa roorroo ilmi dhiiraa, gaafa xiiqii ilmi dhiiraa. Xiyyaara qabsoo keenya hayyootatu bararsee beensilli isaa dhiigaa gongubee lafeetti cabsee murtis gadaa Mustafaa Harawee qabsoo sirbaa fi dhukaasa qawwee eebbisaaf usmaayyoo hirmiin ba'ame akka laaf jireenyaan iyyaan dhabame biddeen lafee daadhii baaburatti daaksifame ittoo foona caalu hundeessattiin godhame. Nyaannu jiraan du'aan oollee nuti hima baafanna gumaa koodee walee normaa sirna ofiif kaatti dhalee maalimaa wajjin kaatti. Bu'aa qeerroof qarree ce'umsaan wal garree faffacaatii ammaa waan jettuuree lammaa. Shanee fi abaa'oo OLF fi kafaa'oo hin barreenaa bartuu Oromoodhaa martuu. Teephamaa mollite suphuuf yaaluu cite qeeduudhaa galmaa godhuuf qeeraa qalmaa. Shaggarii fi dirree dhabuu waan hin jirre ifannee bulchuu alagaan hin bulchuu. Biyya kan keenyaa Oromiyaadha.
Morning in America, good afternoon in Europe, and good evening in Ethiopia. My name is Zakaria Sailu. I'm a founding member of International Oromo Lawyers Association. I'll be hosting today's discussion focused on the charge filed against 24 Ethiopian political prisoners in what I call trial of the century. This discussion is organized by the International Oromo Lawyers Association, IOLA, and Oromo Protest. Thank you both organizations for giving me this opportunity to moderate the discussion. We have today 4 panelist lawyers amongst us who come from different backgrounds of the law. I hope you will enjoy today's session, and now I'm going to go ahead and introduce them one by one based on their alphabet. The first one is Bahar Umar. Bahar received his LLB from Haramaya University and LLM from Addis Ababa University School of Law. After graduation, he worked as lecturer of law at Ambo University, and then he traveled to UK and earned his LLM degree in International Human Rights Law from University of Essex, UK. He's been an active AULA member for several years. And the second participant or panelist is Daniel Ajama. Daniel Ajama received his JD from Seattle University School of Law. He's a former prosecutor with King County in Washington State. He's currently in private practice focusing on criminal defense. And our third panelist is Daniel Webishet. Daniel received his LLB degree from Faculty of Law of Addis Ababa University, an LLM from the University of Michigan Law School, and a JD from University of Maryland Law School. Between 1992 and 1995, he worked on various rule of law and constitutional reform initiatives in Ethiopia, primarily serving as the program coordinator of the Human Center at the Faculty of Law of Addis Ababa University. Currently, he practices corporate and business law in Washington, D.C. area. And the last panelist is Ndesa. Ndesa received his LLB degree from Addis Ababa University and master's from George Washington University in Washington, D.C. In Ethiopia, he worked as a legal expert for both the Special Prosecutor's Office and the Ministry of Justice. He also worked as district attorney for Commercial Bank of Ethiopia. Currently, he is an independent legal policy researcher. To say Ethiopia is going through one of its most difficult time in history is an understatement. In many ways, the way this trial of the century against Oromo leaders and others will be unfolding will define what the future of this country will look like for many, many years to come. In fact, according to some, the fate of this country, that is, whether it will continue as a country, may hinge on this trial. The days of Hachalu Hundessa and subsequent arrest of Jawar, Bakkale Garba, and others, and the Skandarga and Lidita Ayalo is indeed a landmark event. Future historians may even divide the history of Ethiopia as pre and post assassination of Hachalu. It's akin to that unique situation in history where the death of an individual will have a colossal effect on the country. But it's only in the strictest sense that the assassination of Hachalu is the cause of the riot that ensued. I'm not saying his assassination is the cause of all the killings. It's just a trigger. Had there not been a deeply divided country, all the intercommunal killings would not have occurred. And Jawar and Bakkale Garba and others did not create the deep division in the country. If we really, really want answers, we have to look deep and redress the imbalance of power that marginalized the majority of its people, and it's the cause of endless strife that holds them in bondage, as John Markakis stated in his book, The Last Frontier. A deep dialogue and reconciliation is what is needed to heal this country. Hachalu is assassinated, but his assassination and the question of who assassinated him, the trial of his killers, and seeking of justice for him is overshadowed by this trial of the century. Unfortunately, riots after assassination of leaders is not new in this world. Even in the developed world like USA, when Dr. King was assassinated, riots broke out in more than 100 cities across the United States, with some raging for several days. Hundreds of buildings were burned and thousands of arrests were made, and more than 40 people lost their lives at that time. Washington, D.C. was almost burned down. And the same also happened when Indira Gandhi was assassinated. Close to 20,000 Sikhs were killed all across India, close to 3,000 alone in New Delhi. I could go on, but as seductive as the political aspect of this trial is, today we're not going to focus on that one. The focus will be on legal issues. We understand that sometimes it's very difficult to disassociate the legal from the political, but in today's discussion, we will try as much as possible to just do that, to focus on the legal aspect of it. Having said that, then I'm going to go back to our panelists and I'm going to ask them a couple of questions. First, I'm going to ask Bahar. Bahar, can you please, in short, describe for our audience what the charges against Jawar and the others are, and what's the status of the case as it stands currently?
Thank you, Zacharias, for chairing this amazing panel of experts. Thank you, Iola leadership, for organizing this Iola panel. So the charge, as you say, the charge of the trial of the century is a charge which is brought against Jawar and the other 23 defendants. In general, the charge is based on contravention, alleging contravention of criminal code, anti-terrorism code, firearm control proclamation, as well as telecom fraud proclamation. Basically, the major charge based on ordinary criminal code, Article 240, which deals about civil war. But basically, they were charged, or the charges pressed against the defendant by alleging that they have instigated communal violence, and they have coordinated, or they have conspired to topple government by engaging violent revolt. So that's the major charge. The major part of the charge is based on this count. Basically, the charge is composed of 10 counts, but 5 of them were pressed against Jawar Mohammed, including terrorism charge, telecom fraud, and firearm control proclamation were pressed against Jawar Mohammed. But the Article 240, which deals with communal violence and revolt against government, or in general about civil war, is pressed against pretty much all defendants. And so they were accused in the charge. The public prosecutor framed that the defendant organized it to topple government by calling that the end of government would be by October 5. So there would be no government after that, and the transitional government should be installed. And the charge also alleged that the intercommunal where violence was committed. Regarding the terrorism charge, which is pressed against Jawar Mohammed, the charge is based on Article 6, sub-Article 2 of the amended proclamation of anti-terrorism proclamation. It stated that it alleged that there were preparation for commission of acts of terrorism. And again, against Jawar as well, the telecom fraud proclamation charge is brought, which basically state that he installed the telecom infrastructure bypassing the telecom without having license, and bypassing telecom control. And the last charge that brought against Jawar is that he bears arms without valid license. So this arm control proclamation, or the holding arm without license, is placed against Bakale Garba and other defendants, who were most of them were the security details of Jawar Mohammed. And so basically this is the charge. The charge was now sent or given to the defendant. The lawyers asked that they need time to prepare to respond to the case. So far, the charge is not read in the court of law, and so the charge may be read in the next court appointment. So the current status of the charge looks like this, and that's it about the charge.
Thank you, Bahar. Let me now go to Daniel Wobishet. Besides Jawar and the others, there is another charge that's also brought against other individuals, Iskandar Nega especially. Could you talk about that one and then compare it with the other charge, and talk about the charge brought against it, and then also talk about your general impression about the trial itself?
Perfect. Thanks, Zacharias. First of all, let me take a little bit of a privilege of a minute or so just to sort of thank Ayola and the folks on this panel for inviting me. And I want to sort of say a little bit more about why it's important for us, as Zacharias mentioned, that beyond the politics and the concerns and the way people sort of are grouped into their own camps and alleging certain things against each other, as legal professionals and lawyers, we need to have a broader, non-partisan perspective around the due process and rule of law issues implicated here. So I really like to thank Zacharias and Israel and others who were sort of were able to reach out to me and discuss about that. I also think that it's important for us to acknowledge a couple of things before I specifically talk about the charges against Iskandar Nagga and his team. And I'll also mention, the travesty of some of the situations going on with Lidatu Ayale in the judicial system. I would say, despite all the noise and all the political dynamics there are two or three facts we need to always acknowledge, and that's very important for that healing process. Zakar, as you mentioned, I think we need to acknowledge the victims of the incidents and what happened after Hachalu's days. Whether it's the minorities in various regions in Oromia, in Shashamene, in Arsinagale, and even recently in Benshangul Gumuz and other places. Primarily, sort of what I would consider to be by the incompetent and irresponsible acts of the government and its inability to stop that from happening. I would also like to say that we need to also acknowledge the fact that there was an overreaction by the government and by the security forces, and the amount of damage and the amount of pain incurred by Oromo demonstrators and others who sort of were targeted by that overreaction should also be acknowledged. I think we need to have a very balanced perspective about that. One more thing I would like to say before reading about Iskandar's charges are, I want to send out the shout out in sort of my admiration for the lawyers, our counterparties, our sort of compatriots who are defending all of these defendants, whether it's under the Jawar file, under Iskandar's file, or Lidatu, especially, the lawyers for Lidatu had to actually stand up and defend him, because sometimes, nobody wanted to defend him. I think that the role of lawyers, despite what we personally believe in our political thoughts, to be able to defend the rule of law and to challenge the government and to challenge, cases of prosecutorial abuse, I think is very critical. And I know they are in a very tough situation. I know we are in the safety of this country, but we have to sort of give our shout out to those lawyers who sort of day after day showing up in court and doing the work of protecting the rights under the Constitution and other laws. So briefly about Iskandar's charges, it's so interesting because when I was reading the charges against Jawar and the 24 folks, including some of the folks who are actually overseas or at least being charged in absentia, as well as the charges. There are also a couple of folks being included in the charges against Iskandar. In what Bahar mentioned, I think there is a parallel trend here. I mean, I think, and we can talk about the reason and what are sort of the implications of these charges. But similarly, under the Penal Code of Ethiopia, they have been charged. These 7 defendants have been charged for incitement under Section 240 of the Penal Code of Ethiopia, and that sort of applies to all the 5 defendants. And this is Iskandar Nagga, Sintayo Chakol, Kallab Siyum, Askada Damsey, Getinat Bakale, are sort of the top 5 in that category. And then the second set of charges in very interesting parallel with what Bahar mentioned is the terrorism charge under the revised 2020 statute proclamation, the anti-terrorism proclamation, which we would most probably talk about more in this panel, where Iskandar and a couple of his other co-defendants were implicated in this terrorism charge, and coming up with a plot to burn down churches and mosques and kill a number of government officials, including the former mayor, Takala Uma, and also some insinuations that they were sort of training people in Mota, in Gojam, and trying to sort of inculcate some sort of inter-community conflict. There is also a very interesting part in the incitement part, which I thought was one of the lowest points in any acts of prosecution, And you can see that in the terrorism and incitement charges against Jawar, where derogatory and purgatory terms were actually referred by the prosecutors in sort of inciting one group against the other. And the terrorism charges, it's just very interesting that both the terrorism charges against Jawar and the terrorism charges against Skandar include primarily incendiary and highly politically charged terms to sort of come up with I would consider to be tropes and usual sort of terms to provide that level of detail. So we can talk more about that, and I'm sure we have different perspectives, but those are the main points. And in the situation with Ledatu currently is, despite a court order that actually asked him to be released on bail, he's sort of being shuffled back and forth. It seems that the primary reason for his charges relate to the fact that he had written some book, talking and challenging about the legality of the current government and providing some alternative transition plans. I think apparently he had some interview, at with OMN with Jawar, which seems to be the key sort of trigger for some of the action he's facing, and then some firearms related charges which were sort of added to the process. So let me pause here and then throw it back to you, Zacharias.
Great, thank you. Let me now go to this. We see that across the board there is this terrorism charge against everybody. And this terrorism law has changed very recently. And throughout the history of TPLF and APRDF, it used to be also a catch-all charge against all the political opponents. Could you talk a little bit how this evolved and how it changed and what it means in this context? Can you talk a little bit about that?
Yes, sir. Originally, the Anti-Terrorism Act was promulgated by APRDF, and it has been used primarily to suppress dissent and punish any political opposition to the government in like basically since its proclamation all the way until it was amended. It was amended in 2009, like primarily slightly amended. The Oakland Institute in California, it made an in-depth analysis of this law, and its observation was the law defined terrorism in an extremely broad and vague way as to intentionally give the regime enormous leeway to punish words and acts that would be perfectly lawful in a democracy. It gave that government, in many instances, extraordinary powers to harass and intimidate dissenters. It shifted burden of proof to detainees instead of prosecutors. This law has been harshly criticized by the UN Human Rights Commissioner, several UN special rapporteurs, by the governments of the US and the UK, and national human rights observers. The government used this law even after the so-called change, after the killing of the Chief of Staff, General Saar, and also the Amhara region leaders. The government used this law, the one which was not amended until very recently, until that time. That shows the government wants to use that suppressive law as long as it takes it. The amendment came in at the end of 2019. I think it was passed in the first few days of the end of to 2019, or like the first few days of 2020, with a very slight amendment. At that time, even when the amended law was passed, several political dissenters were in prison, arrested by the old law. This shows, as I said earlier, the government still intends to crack down on dissent, to stifle any political opposition to its rule. And as we saw, its intention when the election was postponed almost indefinitely, the we could understand this law was used on Jawar and Abubakar Garba and Iskander and all the others, primarily to exclude them from the election process. Still, many international, primarily the main international organizations who fight for the preservation of human rights across the world are opposed to this current law, not just the past one, not just the past one, but the present as it is presently. But the government is still using it, and the intent is very clear. It is to put its opposition, the government's opposition, credible choices, options to the government to just put them out of power and continue its rule.
Thank you, Ndesa. Let me now go to Daniel Jama. Daniel, you are a prosecutor, and you understand the role of a prosecutor, and you also understand prosecutorial discretion and prosecutorial abuse. Can you talk from that angle? What happened during this trial? What was the role of the prosecutors? How are they doing their job? And you can also talk about the anti-terrorism law if you want to add something to what it is.
Thank you, Zacharias, and good morning to you all. It is still morning here in Seattle. I would like to start by highlighting what Zacharias stated in his opening remark that sort of summarizes the status of the legal and political situation in the country. Couple points I really struck a chord for me. The first point you mentioned was opposition didn't create the violence that ensued after Hajal's assassination. This is the result of centuries-old deep division, intercommunal rift that we have. This intercommunal violence, that was not the first time, and that was not the last time, as we saw a week or so ago in different part of the country in Metekel area. So these opposition figures are being made a scapegoat, a sacrificial lamb, if you will, for this serious problem that need to be dealt politically. So the charge specifically as stems to Article 240 of the Criminal Code basically is trying to blame them for the existing political problems that we already have. And the second point that the Zacharias also mentioned was the fate of the states, the fate of the nation hinges on the handling of these political prisoners and power sharing in the country. This is really a key term. This has been the issue in the past 3 regimes where government consistently refused to power share, rather imprisoned and prosecuted opposition figures that raised human rights, democratic issues. So this is kind of a summary of the general trend as it relates to political and legal situation in the country. I would like to expand this and talk more in the second part, but I'll go back to the questions you asked me, Zacharias. Right, I was a prosecutor, and the role of the prosecutor is really unique compared to other lawyers, especially defense lawyers or lawyers representing corporations and individuals. Prosecutor, as a state-backed entity, have not just the power but the duty as well. They're not after conviction, rather after justice. They can't use the state resource and the power of state to go after individuals, because that would be really unfair. They're, like I said, they're a public agency. They have to go for the fairness and justice, not just getting a conviction. And they shouldn't be really a tool of the executive branch of the government. But what we see in Ethiopia is completely the opposite. To show that the whole process, this political prosecution we are having at the present, is marred by due process irregularities, to say the least. When I talk about due process and constitutional violation of the political prisoners, bail right stood out for me, as we have seen the courts repeatedly have released arrestees on bail, but their decision, the court's decision, amounts to nothing, as the prosecutor and the police were not respecting the court's order. So let me take some time and say a few things about the bail rights under Ethiopian criminal procedure, its use and abuses as it relates to these political arrestees. For me, the biggest challenge we have when it comes to bail is the prosecutors, the government's ability to appeal to the higher court until they get their way, really, to say bluntly. What happens is, in the lower court, sometimes, if not always, we still have some, fair judges who follow the literal meaning of the law, even though the judicial system is not really, independent as it's supposed to be under the Constitution's Article 78. Sometimes we get this, reasonable outcome. The lower courts apply the rules, the criminal procedures, and let defendants go on bail and attend their proceeding out of custody. However, if the prosecution does not want that to happen, they can always have a way to reverse it. That is primarily in using their appeal right. We have seen this in recent handling of the miscarriage of justice, really, as it applies to the political heavyweight figure Lidatu Ayale. So in Ethiopian court system, when the higher court makes a bail decision, if the prosecutor does not want the outcome or does not like the outcome, they will appeal it to a Supreme Court. And if the Supreme Court rules in favor of the defendant or the accused, the prosecution will take it to the higher court. So starting from, I have several examples. As time permits, I probably will touch on few of them. One will be Bakala Garba's 2017, actually 3 years ago. He was charged with a terrorism charge for similar activities that he's been accused of, and later was granted amnesty. And he took his appeal, his bail right on appeal to the highest judicial organ of the land, the cassation bench of the Supreme Court. And initially, the higher court ruled against him. Bakala's lawyers appealed it to the Supreme Court. Supreme Court ruled in favor of Bakala. Then the prosecution take it to the last review court and won, and the court reversed Bakala's bail right. Same thing is happening with Lidatu. We heard a few days ago that the higher court in East Shoa zone granted Lidatu Ayale 100,000 bail, but prosecutors appealed it to Oromia Supreme Court, and that bail was reversed. So I have several examples. I'll stop the examples here and somewhat suggest a solution to this. When I read the criminal procedure under Ethiopian's criminal procedure code, the way it's written under Article 75 is appeal of a bail decision by lower court can be taken or made by the suspects who were refused bail. They can take this into the next level in the appeal process within 20 days. So what that tells me is appeal should not be the appeal process should be an exclusive right to the suspect. So if a court interprets Article 75 in light of allowing appeal only for the accused but not for the government, this probably cures the problem, the due procedure problem we're having at the present, specifically where the prosecutor always have its way. This is not unique. My suggestion is not unique to the Ethiopian case. Even in the US, prior to the Bail Reform Act, we have this kind of law in a federal prosecution where the government cannot appeal a bail release decision by courts. However, a bail denial could be appealed by the arrestees. So this is one suggestion that we can amend it down the road if there is a political will to interpret this rule. We don't even have to legislate a new law, but pretty much interpreted to allow only the arrestees, the suspects, to appeal bail decision, but not the government. So this is one of the most talked about, the most due process violation that stands out, and most people have been paying attention to this. The bail right is a fundamental right, as we know, in a criminal justice system. It relates to an accused being considered innocent until proven guilty. Any suspect should not be prejudged. If possible, if they meet the conditions of the bail, they should be released and follow their proceeding out of custody. This is granted under the Ethiopian Constitution under Article 19, subsection 6, and under several international law. So I like to draw attention to this violation of bail rights by the prosecutions, almost right and left, in all political trials we're having. We've been seeing irregularities when it comes to bail. If I can transition to my next point, I think I'll stop here and probably use my next chance to go into the next points I would like to raise, Zacharias.
Thank you. Let me go back to Bahar and ask him about the procedural irregularities that may have happened during this trial, starting from the time when they were arrested. What are some of the procedural and even substantive irregularities that happened? Do you want to talk about that?
Sure. There were a range of procedural irregularities that occurred in this highly politically charged trial. Daniel, my colleague, mentioned bail right. but we can go step back and take look at some of the procedural irregularities we have seen even from very arrest. If we remember, the first arrest itself was arbitrary, because according to the Ethiopian Constitution, Article 17, a person should not be deprived of his liberty unless there is substantive law to that effect, and the arrest should be regulated under the Criminal Procedure Code, Article 19, and the following. But how Jars and other co-defendants were arrested? They were arrested while they were holding meeting with the former Addis Ababa mayor about how to conduct the funeral of the slain artist Hachalu Hundessa. So they were caught while they were arrested, while they were not committing crime. So they were conducting a meeting, they were arrested. So the arrest was arbitrary. And again, after they were arrested, they were held in inhuman and degrading treatment, contrary to Article 18 of the Constitution and other constitutional and international law safeguards, which say that a detainee should be held in a manner which respects his human right and his human dignity. But what happened? As you remember, some of the detainees were beaten up, including, for example, Shamsuddin Tah was bitterly beaten. Some of them were tortured, and most of them were held in a bad situation, so much so that some of them were exposed to COVID-19. We can read the case of Dajanet Afai was exposed to COVID-19, and Bakale Garba and Jawar Mohammed were held in solitary confinement. I think Iskandar Naga and his co-defendants were also held in a solitary confinement. So this detention in inhuman and degrading treatment flies against the constitutional protection, and even this in on itself constitutes torture. And on top of that, the law dictates that prolonged detention is unlawful. Article 17, sub-article 2 of the Constitution provides that no person should be held, detained without a charge pressing against him or her. So as we saw, Jawar Mohammed and the co-defendant were held prolonged detention more than 80 days, more than 2 months or close to 3 months without charges being pressed against them. And even to prolong the detention, the prosecutor brought up a procedure which was not in a use, if my memory correct, the procedure which was in disuse for a long time, the preliminary inquiry. It brought up the preliminary inquiry basically to prolong the detention, and so that they buy time and cook some of the evidence, or they invent the crimes. So most of, above all, they were as utterly disregard for the protection of presumption of innocence. The Constitution states that a person should be presumed guilty and presumed innocent until proven guilty by the prosecutor. But until right from the arrest, the detainees were presumed guilty by the officials and by the media. They were subjected to avalanche of media smear campaigning. Even the Prime Minister himself called them about the anti-peace, the traitors, bandas, stuff like that. And the former attorney referred them as criminals while they were in the proceeding, while they are still presumed guilty. The former Attorney General referred to them as criminals, and different officials referred them as terrorists, as criminals, as extremists. And even the one rally, which is to support the dam held in Addis Ababa, called for the assassination of Jawar Mohammed. For example, they killed Hachalu killed Jawar is the next, or Jawar was to be the second who has to be eliminated. So basically, they were subjected to massive media smear campaign and defamation. And sadly, as late as Thursday, a new Attorney General, who is praised and billed as independent, technocrat, and liberal-minded, you label them as ultra-nationalist, militant, violent criminals, individuals. So this kind of labeling from the prosecution office, from the prime minister office, from the party appointees, even the Amara branch of the Prosperity Party in its Lekki document make that the guilty of Jawar and his co-defender is an issue that make or break they stay within the National Prosperity Party. And the officials were repeatedly called on, they repeatedly appeared on media and say that they should not be released. They should, they are criminals. They are responsible for committing violence, and they should be get what they deserve. So this kind of massive and unlawful, illegal smear campaigning and the defamation were leveled against the co-defendant, which really eroded the presumption of innocence. So these are some of the major procedural irregularities, and we can come to the substantive irregularities of the principle of criminal procedure, criminal code, when we go to the details of the charge. Thank you, Zacharias.
Thank you, Bahar. Daniel, could you also add to what Bahar said, and then also talk about the right of speedy trial in the Constitution and how justice delayed is justice denied, and also talk about it in context of the upcoming elections. Elections going to happen very soon, and then these individuals who were thought to be big contenders would be in prison at the time. And what's the relationship between the two? Would the elongation of the trial itself feed into that conspiracy theory or the speculation that's going on?
I hope you're asking me, the Daniel W, not Daniel Ajema, just to be sure. Okay, right. So to add on to what Bahar said around procedural issues, I think there is a key element, and I'll go to your point around the implication of how this sounds to be very politicized, and the abuse of discretion in process by the Attorney Generals is very clear from my perspective, at least. I get engaged into these discussions with many of my friends and others, around why, I have some concerns about due process and the rule of law and things of that sort. So there are a couple of things I always mention. I just want to make sure that we're grounded in terms of how we articulate this. First of all, the idea of the rule of law, which is something which I've heard, the Prime Minister and the Attorney General and everybody sort of, making point. Even folks in the opposition who are sort of opposed to the idea of some of the defendants make this point about this is about the rule of law, and we're trying to enforce the rule of law. And I totally understand that you can't allow unlawful incitement and chaos. But the concept of the rule of law is not a carte blanche authorization for the government to overreact and to do some of the stuff which you're doing, in terms of denying substantive and procedural due process, politicizing the prosecution process, and charging people similar to the old TPLF days, really, of terrorism and coming up with all that implications that comes with that word and with the invocation of the anti-terrorism statute. So that's the first point about the rule of law. It's really primarily a limit on government. It's not primarily a method for the government to impose on others an unlimited sort of use of governmental power. It's primarily a way for individuals and communities to be able to seek redress and to get protection from the government. That's the essence of the rule of law. Plus, your disagreement or your, even to some extent, I consider it to be guttural hatred some people have for some of these politicians on both sides. It could be what people feel about Jawar or what people feel about Skandar. it's totally irrelevant in as much as what the due process requirements in the constitutional guarantees are concerned. And I think people sometimes miss that fact. I mean, I have a number of things I disagree with Jawar on a number of his political positions. The same thing with Iskander. But I think the constitutional principle and the idea of due process is something which should be really treated distinctly from our political perspectives about what needs to happen. So before I address the sort of impact on the elections, to your second point, I would really like to emphasize what Bahar mentioned. The whole process, not just of the preliminary inquiry, but this whole testimony behind curtains. I mean, like, people not having the right to sort of confront witnesses, or even people who might be providing sort of testimony against them. It's very Kafkaesque and very sort of reminds you of all the old things we have read in law school about the abuse of authority and dictatorial decisions. I think those are procedural issues that need to be addressed. I mean, hopefully in appeal or in the next step of the process, that would sort of be some of the procedural items that need to be really challenged by the lawyers for these defendants as sort of vitiating the nature of the charge. Let me say one more thing. I was willing to give the Attorney General some benefit of the doubt, because I know it's sort of a transition period and there's a number of things that are going on. Tough situation. And clearly there has been damage on the ground. They have to prove if their incitement charges need to sort of hold water. Some of the if you look at the charges and the utterances by Jawar or by anybody else related to what constituted the fighting words do not seem to be, from my perspective, illegal. I mean, from a principle of legality, you just cannot attach liability by analogy and by inferences. There seems to be a lot of that added to that charge, the penal code charge. What really drove me to really second guess and doubt the entirety of the operation, and it definitely, you can see based on the charges against Iskander and Nidatu and even Jawar, are the terrorism charges, knowing that that's just a loaded politically motivated position in terms of adding that one. And that, I think, has really hurt it really has hurt the credibility of this entire enterprise by the Attorney General's office. And the fact that the new Attorney General, who Bahar was mentioning, I haven't dealt with him, I don't know him personally, but the fact that this type of shoddy work was sort of written under his command is actually very troubling from my perspective. So let me say a few things about the elections. Look, I try to stay away from the electoral politics or from the actual political party situation, so I may not know all the facts. But clearly, the targeting of Iskander and Nidatu, especially Iskander and the Balderas party in Addis Ababa, and obviously the strength of the Oromo Federalist Congress and Jawar's position, as well as all the other leaders like Bakale, clearly has provided some what I would consider to be electoral challenges to the Abiy administration, at least to the party. I think we need to make a distinction between the party and the government, even if that's a very difficult thing in Ethiopia. But I think, unfortunately, Abiy and his party are using the incidents after the days of Hachalu as a way to round up in the nature of these charges, and the manner how they are being prosecuted and the manner they are being presented is really establishing that fact that this the primary focus here seems to be sidelining potential opposition leaders from the next election. Over to you.
Thank you, Daniel. All right. Let me go back to Ndes and ask him about this terrorism. You talked about the terrorism charge. And this time around, also, it's not only about the terrorism charge. In fact, the most serious charges they're charged was under Article 240 of the Criminal Code. What was the intent behind it? And then also talk about what the effect of this trial will have on the country or on the legal system itself, and then even about the process of the democratization and any other things attached to it. What would be the effect of it on those issues?
Okay. Abu Zakaris, you on the outset you have said like this trial is very extremely serious trial with serious consequences for the country's future. I agree. Now, when we talked earlier, I talked about the anti-terrorism law and the government's intent in using what its previous progenitor, which is APRDF. APRDF 1 used the anti-terrorism law entirely to stifle dissent. And this government, this regime, used the same law until the end, until even the last minute, while it was being amended to put its opponents in jail. After it was amended, we are realizing the same intent being displayed by prosecuting Jar, Obo Bakala, Iskandar Naga, and Mr. Lidatu. And also, yesterday, also a number of people, Oromo citizens, were arrested in Harar for taking down the statue of, I think, Ras Makonnen, being charged by the same anti-terrorism law. We know it's not only Ethiopia. This anti-terrorism law is a favorite tool of all dictators. You can go to Nigeria, Pakistan, Philippines, and many other countries, militarily strong countries, including Turkey. The same is we are witnessing the same process happening in Ethiopia. It's not only the terrorism law. The Ethiopian government charged Jawar and his co-defendants with the ordinary criminal law. This criminal law, particularly Article 240. Article 240 is part of Part 2, Book 3, Chapter 1, Section 1. So Section 1 is about crimes against the constitutional order. The entire Oromo movement was so that the government, APRDF, implement the constitution properly. The whole movement was based on claiming rights under the Ethiopian constitution. None other than Jawar and his friends called for the respect of the constitution. Now we are witnessing the government is charging Jawar and Abubakar Garba, both internationally known and recognized civil disobedience fighters. Abubakar Garba is a translator of Martin Luther King. In so many meetings, in so many venues, both Jawar and Abubakar Garba, and also leaders of the Oromo Federalist Congress organization have shown their allegiance to peaceful way of struggle. So the government now is charging them by disrespecting or trying to overthrow the constitutional order. This is a serious crime under the law. It's where the crime, sub-article 2 says, where the crime has entailed serious crisis against public security or life, the punishment shall be life imprisonment or death. This regime, just like its parent regime, EPRDF, has never shown respect for due process or legality. All the claims Jawar and all the other defendants brought about, demanded, was just causes. All the Oromo protesters, all the Oromo, the lives the Oromo people lost, were just demanding self-rule under the constitution. Nobody, none of the Oromo leaders ever demanded anything which is not given to them by the Ethiopian constitution. All this struggle, all this life lost was demanding equal rights and self-rule under the Ethiopian constitution. We know after the Oromo protesters were ignited, Amhara youth called Fano also joined them in overthrowing the TPLF regime. The two went as far as under basically under the leadership of the former president of Oromia region, Obbo Lamma Magarsa, and also Gaddu Andargacho. These people who, for like a long time, everybody thought, and especially EPRDF 1, the leaders of EPRDF 1 thought, will never be brought together, came together, and they, like Oromo people, citizens, went as far as to Bahardar, to Tana Lake, trying to help out in taking out the weed, and everything seemed okay. And there was a possibility if this government really focused and followed the law strictly, there would have been a bigger chance of peace in Ethiopia. But now, under this charge from not only just from the charge itself, but also from some of the evidences I saw, the government is basically trying to outlaw legitimate Oromo demands. It's basically using this prosecution as a backhanded attempt to outlaw the entire Oromo demand. In so doing, especially when you see the charge under Article 204E and also under the amended anti-terrorism law, when the prosecutors accuse the defendants that they are instigating Oromos against Amharas by saying Naftenyas are killing us, Naftenyas are coming back to power. This government, in its intention to stay in power, is making lasting enemies between the Oromo people and the Amhara people. Just like they are excluding, basically forcing Tigray to secede. So it's a dangerous prosecution, a dangerous enterprise. My advice to all the prosecutors in Ethiopia and to the judges, this is about the continued existence of Ethiopia, or the disintegration of the country. The Oromo people are not going to give up on their rights. The struggle will continue. It cannot be. The government cannot, by any force, by any amount of force, cannot silence the Oromo people's demands. People will struggle. People will die. It's going to be catastrophic if the government is just following its way, its plan. Ethiopia is going to disintegrate. So I plead with legal practitioners in Ethiopia, judges and prosecutors, to really uphold rule of law, and as much as they can. I know it is very risky, but as much as they can, they should uphold the defendants' rights. They should release the defendants and let the political process, the democratization process, continue. That's all I want to say.
Thank you.
Mr. Zakaria.
Thank you. Let me go back to Daniel Ajama. We know that one of the basic charges about instigation and inciting of people to rise up. They're saying that the Jawar and Batkale incited people to go out and kill others. So using the clear danger test, the present danger test, clear and present danger test, what's the connection between the two? Is there any evidence towards that? I really wanted to go deeper here and see about the charge. What are the standards that they are using to say that they incited or instigated people to do the acts? I'm remembering what Justice Oliver Wendell Holmes said. This, I'm just quoting here. The question in every case is whether the words used are used in such circumstances and are of such a nature to create a clear and present danger that they will bring about the substantive evils that Congress has the right to prevent. And then he uses as example the person who falsely shouts fire in a crowded theater, causing panic. So in this situation, where is the speech that Bekele and Jawar made? How did it lead to imminent, immediate disorder in the country? Could you talk about that a little bit? And then also talk about the causation in a legal sense, whether what they spoke is the immediate cause of what happened in the country after Hachalu died.
Thank you, Zacharias. That's really an excellent question. The biggest problem is I have looked at both of the charges under Jawar's file and Iskinder's file, and both the accusation starts really a year before the incidents ensued after Achalu's assassination. In Jawar's case, I think it's about exactly a year, September of 2019. In Iskinder's case, it's actually longer. So the prosecutions mentioned several incidents that happened throughout the year. So, in a criminal sense, you have to have a specific fact and a specific acts. If they are alleging a crime has occurred within that year, what were the prosecutor doing? Why not prosecute them? Why wait until this last incident? So in looking for causation to prove a crime, where are we going to start? Which activity, which speech are we going to use? That's a problem. I think the prosecution will have hard time to prove, and judges probably will push for a more specific, certain, narrowly tailored charges to be brought, or amended the present charge to be really narrow and specific to incidents in time and place and all of that. But to answer your question directly, I don't see correlation, let alone causation. There is no causation. This violence occurred, like you indicated at your opening remark, because of the already existing rift between communities, ethnic division, cultural, religious, and so on. That's the cause of this problem. This would have happened if Jawar, Bakala, and Iskandar and Lidatu do not exist. This is a countrywide, deep-rooted problem that we have. So, to look for causation, we have to know a specific incident, a specific fact, a specific speech, so we can apply it against the law. In this case, we don't have that. What it really surprised me was, as we know, Jawar Mohammed led the youth protests in Oromia a couple of years ago or so, and brought about this so-called, failed reform that I call it now. He probably deserves the lion's share if we talk about credit. At that point, he pushed for non-violence struggle, which also entail market boycott and road blockage, somewhat disruption of traffic. But presently, I haven't seen even that. Right after Ajal's assassination, I didn't see any statement, any speech that called for violence. As Idessa, went in detail. If I understand there's always hate on each side, on a different side of politicians, but Jawar Mohammed, Bakala Garba never called for violence. Not on the community side. The government alleged they targeted for violence. I actually like to read a quote from Jawar's interview with a person named Andrew Ducote, made in December 7th, 2019, right after the another violence that ensued after the government tried to take away Jawar's security detail. Jawar said, "These days, I may have disagreement with the Amara elites on the status of multinational federalism and the future of the country, but these days I worry much more about the Amara civilians than anyone else." Jawar always expressed his concern for the people, the exact people the government is calling he instigated violence against. So there's no causation. They were not even engaged in the previous non-violence tactics to disrupt, this dictatorial government's activities. But what is really interesting for me is the Prime Minister itself praised this sort of activities by the youth. Few years back in his speech in Ambo, my hometown, he said, obviously that struggle brought his government up, and he acknowledged their activities, including, the peaceful demonstration, road blockage, market boycott, as the right tool to bring about democratic change. So if the people feel they need to, the current government is dictatorial and they need to bring democratic change, why not use the exact strategies the government of the Prime Minister admired and called it as heroic a few years back? So I don't see any word activities, even less in the present than in the past, by this opposition figure that establish a causation to prove a crime. They're being accused, they're being charged for the country's existing political division, political problems, as you indicated earlier. The charges themselves go in detail, saying they were caught calling this government a return to the dictatorial past, the Naftanya regime and such. These are pure political activities which is permitted. This is free expression of their ideas and organizing. So it's hard really to establish causation. However, what we have is we need to draw attention of the international community, the human rights community, donors, and all friends of Ethiopia that the current government is involving a complete disregard of rule of law and separation of power. The way I see it is courts are being used as another tool in the prime minister and people surrounding him's effort to save the nation. They consider themselves as a messiah who probably called by Almighty to save the nation, and they have their own idea and plans how to implement that. So they're not bound by any institution. They don't want to respect the rule of law. If they have to, they can bend the rule of law as it applies to this bigger mission they think they have. That's what we've been seeing with the president of the Supreme Court, the way she worked with the executive to extend election, and also the newly minted Attorney General. His position and name was mentioned previously by panelists. I'd like to say a couple things on that regard, actually. He wields a significant power, in Ethiopia. Since we don't have independent judiciary, the AG's office have strongest power in a sense of criminal justice system. He will also be overseeing this trial of the political opponents. A lot of people have high hopes before he was appointed to start his job formally. I listened to his presser just a couple days ago, and a couple things stood out in his answer to questions by journalists. One, when he was asked that the government is using or politicizing the arrest and the prosecutions of opposition figures, he responded by saying it is actually the arrestees themselves who are politicizing their case, not the government. The funny part, however, was in the same speech, a minute before, he called these arrestees as ultra-nationalists who are involved in non-peace movements. This is a political statement. He himself made a political statement as he was sat there as an Attorney General of the nation. The whole political question we have in Ethiopia is about nations, right? Nations' right to exist as full nationhood, not melt into one identity. This has been the nation's question, has been the country's question for half a century, if not over that. So he himself make a political statement, but also the government controls, has a monopoly on the media. All state medias have been calling, like Bahar indicated earlier, for a serious measure and prosecution, basically to be taken by the government. They have been bringing justice, and they use their news segment to frame and call for a serious measure to be taken on these political prisoners. So, all independent media outlets have been closed in the country, and the government successfully have been politicizing the arrestees case. So that's really disingenuous in his part to call the arrestees are making their case politicizing their case, but not the government. when he was also asked about the due process and constitutional violation of the political prisoners, his response really surprised me. What he said was, well, in light of the number of cases we have, the volume of people we arrested, I mean, that's not significant. He pretty much said that. He did not apologize or show an effort to remedy the situation, but he was simply saying, well, when you have a lot of cases, it's okay to violate people's constitutional and due process rights. So this is really concerning for me, to have an attorney general which wields so much power and will be overseeing on the prosecution, taking a political stand, making such statements, really is concerning for anybody who's watching the legal situation and the criminal prosecution of opposition figures in Ethiopia. So I went on and discussed some issues, Zakaria, that you didn't ask me, but as to the causation, I don't see any causation or even correlation to tie the crimes, the widespread crimes happening thousands of kilometers, hundreds of miles away from these political prisoners. There is no statement, there is no activity. The government alleges they have some information, but as we know, that is also being fabricated from what I see and been following. So there is no causation.
Great. Thank you. And I was about to come to what the new Attorney General said, and you made a very great point. And I want to dwell on that again and then ask Bahar about that statement where he said these detainees were ultra-nationalist, violent, and what's the other term that he used? He said they are militant. We know Ethiopia is politically a very divided country, and there is a spectrum of political thoughts in the country. Some believe that the problem in the country, the division could be solved only through the multinational federalism. And then there are others who want to emphasize on Ethiopian nationalism to resolve the problem. And then there are other outliers, and then there are others in the middle. But generally, we see that kind of a division. Wouldn't his statement show, it's almost like a Freudian slip, that almost that they are prosecuting these individuals because of their political thought? And what's your take on that one, Bahar? And then also, this inciting and subvert, it's almost like what the Chinese do against their dissidents. Every time they charge them about inciting subversion of state power. Isn't this also very similar to it? Are we going back to the way the Chinese are dealing with their dissidents?
Okay. Thank you. As Daniel said, the Attorney General is held in high regard for his, especially for his scholarship. Is one of the fine constitutional lawyers, but unfortunately, he's subservient to the ruling party and he's doing their bidding. And his statement prior to his the latest presser, he released, as soon as he was appointed, he released a statement which stated that the alleged human rights report by the International Human Rights Organization were basically fabrications, lies. We are upholding rule of law. We are not arresting people for their political opinion. He was doubling down on that, and even he further stated that he further vindicate that the detainees were held for their political opinion. He called them ultra-nationalist and militant. So who is, after all, to measure which opinion is ultra-national, which one is liberal, which idea is moderate? Freedom of for your surprise, this is a person who did his PhD on freedom of expression, and now is trying to stifle and overlook criminalization of freedom of expression. That self is an irony, and as that it may, but the position of the prosecutor and the position of the state in general vis-a-vis the defendant is definitely compromise the freedom or their presumption of innocence, and this would affect all the judiciary's wisdom and decision. Judiciary is not independent, that we'll discuss it later on maybe, but the state is positioning itself into one corner of political divide. As we know, in Ethiopia, people are polarized across ethnic and across ideological lines. So you cannot accept one ideology, the ideology and rhetoric of some ethnic elite as a national, as a reconstructionist idea, and you cannot criminalize others' alternative viewpoint on different host of issue on federalism, on the constitutional development and the political transition. Prime Minister, during this early formative stage, he was like striking balance among the different political line. But recently he took a side, and the state, the party, the prime minister, all are running against multinational parties, multinational parties and individuals who calls for redistributive justice, who call for reconstructing the country by respecting the multicultural reality. Rather, they're adopting for greater tradition historiography, which calls for a return to the glorious past, which was not glorious for the larger southern political south communities. So this is a politicization of expression of freedom of expression. And just to add to this, as you know, there is a clear legal principle that calls for the principle of criminal legality, which indicate that a person is accused or charged with a substantive law which proscribes the act. You cannot invent a crime by analogy or by wide interpreting the criminal law, and that very principle is stated under Article 2 of the Criminal Code. But when we look some of the allegations provided in the charge, you are surprised whether you are reading a criminal charge or tabloid newspaper or Facebook post, because there are a gossip and hearsays here and there. And for example, some of the statements are clearly political statement. For example, criticizing Naftanya a political order. This is a political speech. How this can be a criminal, let alone how this can be considered as inciting intercommunal. And again, calling for the transitional government, providing their own constitutional interpretation, arguing that if the election is not held on time, the government term will expire, and then there will be no lawful government, no legal legitimate government. That's one interpretation of the constitution, and they are entitled to their opinion. And so this is one of this. The charge alleges that this as a crime that is calculated to toppling government. While there were wild statements from the prime minister and from the other officials regarding a range of constitutional and legal issues, and when they were not held account for. And what surprised of all is that the term Naftanya or Naftanya system is not equated with any ethnic group. Even the charge itself occasionally stated that the defendant said that Oromo were killed by Naftanya system. Right? So what? That they were a system. So criticizing a system and agitating against the system cannot be considered as inciting political violence. And you cannot create imaginary connection between a system and ethnic group. Naftanya, now the charge is trying to draw an imaginary connection between a system which is labeled as a Naftanya and as Amara ethnic group. Nowhere Amara is equated with Naftanya or with Orthodox Christianity. That is the imagination of the prosecutor. And even the Prime Minister in their press statement released in English some months ago, they said that there was a Naftanya system, but that system was uprooted in 1974 revolution, and there is no more Naftanya system. So they even admitted that Naftanya is a system, and it has got nothing to do with ethnic community. So where they come with where they bring that calling out Naftanya or criticizing Naftanya amount to calling for attack against Amara ethnic group. So that's not acceptable, and that's not logical. And again, they say that Ajalu was killed. They accused, can consider this as a criminal and as inciting communal violence for saying that Ajalu was killed by Naftanya or by the government. That's their opinion. As long as there is no prompt independent investigation is conducted and the perpetrators are brought to justice, everybody is entitled to this opinion. Even the president, the Oromian president, a night after Ajal was arrested, and the camp says that TPLF is behind the assassination, but he has not brought any evidence. So should we consider that now the president tipped Tigrayans against Oromo because he alleged TPLF? No way. We cannot stretch this kind of imaginations and criminalize political opinion. So basically, this charge does not fulfill any legal requirement regarding the principle of criminal justice, and it's purely a political opinion. It's a politicized trial aimed at eliminating political opponent from electoral contest. And by design, now the government is calling to hold election after they arrested their formidable opponent. Thank you.
Great, thank you. And one of the things that surprised me when I read the charge was that it almost looked like a political statement, as Bahar said. There is no specificity in some areas, it's just a broad political charge. And so, Daniel, we see it's, and the term Naftanya is sprinkled all over the charge. And what do you understand by that? And then if you could talk about the difference between opinion and crime, advocacy and crime, and would the charge in some ways try to criminalize thought rather than the act itself? And what's your take on it? What's the relationship between also freedom of speech and the charge itself?
So thank you for giving me this opportunity. And I think I sort of tend to have a more nuanced position around this. From a legal procedural due process perspective, I totally agree with Bahar's position that the invocation of the opposition against the Naftanya system, or the fact that the government mandates ends up by the end of Maskaram, or that we need to have a discussion about setting up a transition government. These are sort of exposition of political opinions, and they are not by themselves from a principle of criminality perspective shouldn't be the basis why you need to have you need to charge folks. Now, the benefit of me joining this discussion, and I'll try to be more because I think there's a benefit of having this dialogue. As someone who grew up in Addis, very proud of the experience as an Ethiopian we had in general, and I understand why people have different perspectives about their Ethiopian experiences. And as a person who primarily, comes from the Amhara background, I would like to sort of state that the theoretical academic sort of discussions we're having around the Naftanya system, I think, make perfect sense. I mean, I support, and I think that when we think about Ethiopian history, when we sort of analyze Menelik and his legacy, we need to have a very balanced perspective about the good and the bad, and we sort of need to articulate that one. So there is the political argument, the socio-political impact of what words and phrases mean, and their impact on the ground, and the freedom of speech and the constitutional protection, which I'll turn to in a minute. I think, and this is sort of a call out for everyone, we need to sort of, the country is in a tinderbox at this point in time. There is so much polarization on both pieces. And we need to sort of come down, maybe sort of try to bring down the rhetoric and be able to have decent discussions. So when I and Zacharias, or when I or somebody else on the academic sort of the more nuanced version talk about the perils of the Naftanya system and what we need to do to remedy and rectify the effects of that system in terms of distribution of rights, having the multinational federal system, making sure that there is a need for dialogue around those things. They seem to be pretty nice when we're like, you're in Minneapolis, I'm in DC, and somebody is in Seattle. I think that's a very interesting position for us to engage in. But when you have, in situations where there is a problem for lack of context, for lack of nuance, and already due to the historical sort of grievances folks have and communities have against each other, and the economic situation, when those words land in those situations, it's actually going to have very dire consequences. So we need to acknowledge that we need to understand that there are situations where that might have a different nuanced perspective. But from a pure legality perspective, under the criminal code, under the Constitution, the fact that Jawar or Bakal or others are sort of advocating against the Naftanya system is not a criminal act. I mean, it's an expression of what happened in the system. And I know many people are going to kill me for this, but I really am bringing this parallel. It might not be a very good analogy, but when we're thinking about, in America these days, we're talking about, dealing with the effects of white supremacy and white privilege, and sort of the historical, injustices in this country. We're not accusing the white people currently. I mean, there might be people who might be espousing that opinion and will be pushing back against them, but you need to make a distinction between the system and the effects of that system, versus what's really the individual protection of rights. I would actually even envisage that the challenge for the regional governments in the either the EPRDF or now the Prosperity Party challenge under the Constitution today is their failure to maybe change practices, change legislation to give protections which are currently provided under the Constitution. Despite the multinational federal system, we have freedom of movement guarantees for any Ethiopian to live anywhere and reside and have a domicile. There are protections about equal protection of the law. And I think enforcing and working on those principles would be key in sort of countering the whole sort of back and forth between different communities around instigating words. But from a pure principle perspective, I'm not saying that in Ethiopia we're going to use the extreme sort of freedom of speech and First Amendment jurisprudence we have in the U.S. I think we need to make it a bit nuanced, but I think it's very difficult for us to justify, for the mere reason that somebody had talked and criticized the Naftanya system, that's actually a criminal conduct. that really is as Bahar was mentioning, it's basically criminality, inference upon inference, and by analogy, which is not permitted by the penal code.
Great. We're running out of time. I wanted to ask everybody if you are the defendant's attorney, what would be your opening statement? I'm not going to ask you that question now. Just to save time, I'm going to ask everybody one question, and then we'll take a turn around, and then we'll discuss that. Do you think that the defendants will get a fair trial from this court? And I want you to discuss in that relationship the independence of the judiciary in Ethiopia and its importance for democratization, for the rule of law, for everything. And let me start from Daniel Ejama, and then we go to Desa, and then Bahar, and then finally Bubishet. Daniel Bubishet. I just wanted to distinguish with the two Daniels. That's why I said Bubishet. All right.
Thank you, Zacharias. Well, that's a good question. Will they have a fair trial? The answer is an obvious to most Ethiopians, really. I mean, political trials have been undertaken in previous governments. The nation has experience with that, and I don't think this time around will be any different. I mentioned earlier, Bakala Garba's charge under the anti-terrorism proclamation 3 years ago. The same person, also Skinder Nega, was charged for pretty much similar alleged crime, if I remember correctly. He was charged for inciting the public and mentioning a parallel with the Arab Spring, that to happen, encouraging people so that to happen in Ethiopia. Same charge, same law, same system, same prosecution. The only change we have is who is at the helm of the execution. I mean, the executive branch of the government. So we didn't have fair trial. We didn't have justice in the past. And we have no indication for that to happen. Actually, it may be even the opposite. In the present, we're seeing judges being arrested for following the law. I think at least I read 3 instances, one in Adami Tulu Warada, where judges were arrested by the police for obstructing the police's work because they were applying the rule correctly and setting people free on bail. They were charged and actually spent about 40 days in jail when the Warada level judiciary refused to side with the prosecution. The prosecution took these judges to East Shawa zone, where eventually their arrests were found to be unconstitutional. We're talking about opposition figures such as Abdissa Raga, who has been arrested about 7 or 8 months ago and no charge has been brought. Initially, he was abducted like somebody being abducted by a mafia group. The government took him in, did not let the families know his whereabouts. This kind of travesty of justice, we're seeing that in this system. We're talking about the judicial officials in Walaita zone, the higher court's vice president, the Justice Bureau's head, Walaita University Law School dean, all these legal experts and judges have been arrested for crimes against the state for pushing Walaita's quest for statehood. So seeing this, how do you expect a fair trial or justice to be served? I mean, from the beginning, the government has failed. The government has shown us they will use the law as a tool weaponize the law against these political opponents, because the government believe they are in a higher mission and the law is there to serve their interests, not to limit on their authority, not as a limit, not as a monitoring tool, but as any tool that could be bent to serve their bigger mission that they think they have. So I don't expect any justice to be served, and I'm not saying this as a personal biased political person, but seeing the facts on the ground. And most people don't expect that as well. Rather, what probably will happen is, like in the past, the government will arrest oppositions just because it feels like, or its powers are somewhat challenged, and at some point they'll come up with some sort of amnesty, pardoning of these arrested political leaders, because they can't really push through the law in a practical legality sense. The charge under Article 240 carries a maximum sentence of death or life in prison. And they're not going to push and get that, because they know if they will punish these political prisoners, either by days or life, the state may not even survive. You can't hang or kill opposition figures like in the imperial era and survive in the current political atmosphere. So I don't believe a government even believes a crime was really committed. Rather, they're using this as an excuse to stifle, to curtail a meaningful opposition, like it has been said in this panel and by other peoples as well. So no fair trial is expected, I don't believe, by any fair-minded person, as Zacharias.
Okay, thank you. Let's go to Ndesa. Same question.
I muted my speaker. Yeah, I was saying I agree with Daniel Jama. We have seen this is like I never heard judges were beaten because they followed the law, like harassed, extremely harassed, and put to jail even under EPRDF1. Taking the current situation and the charges against the defendants, especially by seeing it from the evidences, some of the evidences which allege that the defendants were seen using or with Oromo resistance flags, or alleging that the Neftanya regime or the Neftanya power is fighting against the Oromo people, which is by no way illegal to say under a democracy. They are just, as several of the panelists said, they are purely, they are protected. It's protected speech. So all this sin against the principle of legality, the government is creating crime out of thin air just to put these defendants and credible potential alternatives to the regime in power out of the election, the coming election. So I don't think the government will go back on its path. We have never seen since this regime, since especially Prime Minister Abiy Ahmed came to power, we haven't seen any affection to rule of law, but rather to military dictatorship. Actually, I don't believe there will be any fair trial.
Thank you. Now we go to Bahar.
Unfortunately, I don't have any hope as well of delivering either a fair trial or getting justice, because historically and currently the judiciary is compromised. There are some good judges individually, maybe, but the institution is highly compromised. This case of Jawar, Eskinder Naga, Lidatu Iyalo, and other high-profile political leaders, their prosecution is political. It's a politicized prosecution and a trial, and I don't expect the judiciary would deliver any justice in this case. Even as we see, as some of my colleagues mentioned, even some of the semblance of justice were trumped up, and judges were arrested for releasing a suspect on jail, or for reducing day of remanding arrest. So I don't think so that is possible. And even if they do, I don't think the judges themselves would be I think their life even is on the line, and the system using its different mechanism may put pressure on the judge, or may even accuse them and stand them in front of court as well. So under this atmosphere, under this tense, politicized and militarized atmosphere, I don't expect any imagination of I don't imagine any delivery of justice. This is a politics, as the defendant and now all of our panels said. I think they have to return to political route, and political negotiation would serve the way out, rather than adjudicating the political difference by judiciary or scoring political point. I think it's good to release those political prisoners and discuss among the political elites, and chart out the way out in political terms. Thank you.
Right, and finally we go to Daniel Ubishit.
Okay, so I will take a little bit of a contrarian view. I'm trying to be as less pessimistic about the situation as possible. I share and I agree the level of concern and the level of experience and precedent is not very convincing. I am also very concerned about the commitment of Prime Minister Abiy and his government to the rule of law. I mean, I can give you a simple example from the last week, where he arbitrarily in a chaotic situation imposed this process where the military and the security can confiscate money from anywhere in the country, which I thought was I mean, you are the prime minister and you need to organize and work through that. And it actually took some time when the whole thing got chaotic for the Minister of Finance and the governor of the bank to come back and try to put a stop to the chaos he created. So I am not belittling the challenge we have for the rule of law and the threat which the Prime Minister poses to that one. But I'm also thinking about the many classmates and friends and colleagues we had, in our career, in our school, who actually are in the bench and in the courts, and clearly understand the implication of this one. So one of the things I would raise would be this is really going to be the test case for the independence of the judiciary, for the new attempt for judicial independence, and they have done some work. So I don't want not to give them credit. I mean, look, they have released a number of people on bail, folks from the OMN group, and there were folks from the Balderas group, and even try to get bail relief Ledetu, and the police and the prosecutors are doing this whole bail switcheroo in a process which just doesn't make any sense. But they have to deal with this thing very upfront, and this will be the challenge for the leadership of the judicial system. And they did. I mean, we can share this with the public, but there was the Supreme Court had a plenum at the end of Ethiopian New Year, and where they come out with very strong statements around some of the concerns they had about respect for judicial independence. The even named some of the outrageous thing which was done in terms of picking judges from their bench and beating judges in some of the regions. I think they understand it. I think they know that this is not right. And this would be the time for them to stand up and challenge this. They could say, they might even entertain, like, we are not going to accept the anti-terrorism law provision. That's totally incendiary, not backed by all the things, and try to exercise some of their judicial merits to do that. And I always mention that there are people who, because they stood for the right thing, when C. Abraha and others were being wrung through the TPLF, prosecutorial system. It were people like Bertukan Medex and others who stood up and sort of implemented some of this relief for the judicial system and for enforcing due process protection. So I am a bit hopeful. Let's maybe might be wrongly placed, but I think we need to give them support. I think we shouldn't just give up and stay. We need to support them. We need to sort of observe this, and we need to challenge them, and then provide comments and criticism as needed. But they are the last the last bulwark at this point in time to stop through some of this prosecutorial misconduct and abuse of discretion. That's my take on it.
I think this has been a very wonderful discussion, and I hope all of you learned a lot from this.
I think Zacharias is frozen or something.
Yeah, it looks like it.
So Zacharias be frozen.
Until the chorus comes, I'm going to say a couple of things. One, I would like to join Daniel Wilushat's call for our colleagues back home to take a historic move and prove the independence of the judiciary. I'm sure this is also a call of Iola and all legal professionals around the globe and friends of Ethiopia are behind. I know this is the biggest sacrifice. The government probably will not let you to take this heroic decision, but I would like to join my colleagues to call upon you to respect the rule of law and make history. And one final point, as a summary, there is no way out in the legal system. What we have is a political problem, and it needs to be addressed politically. The incompetence of the current prime minister is actually the biggest danger for the intercommunal relationship and violence, not the opposition. They have a better, in my opinion, solution and options for transition. They need to be given a chance, and the power must be shared. That's the only way out, not legally. This is my final point. If the Zacharias is back, let's transition to. Thank you.
We end our program.
I think he's signing off. Did you sign off, Zacharias? Are you releasing us?
No, my audio. Hear me now?
Yep. Yeah, we can hear you now.
Daniel, you were talking. I hear my audio is working. I apologize.
I think you're breaking up
Problems?
now.
Just thank you.
Thanks, everybody. This was good.
Thank you, guys. I enjoyed it.
Thanks.